Welcome, everybody, to this episode of Compliance Reality, where we discuss the reality of enforcement and compliance programs today. Today's topic is just use Modifier 25, or don't. Most of us that are involved in healthcare compliance and specifically coding, medical billing, know that Modifier 25 is a modifier that bypasses certain payment edits, and it's appropriate at sometimes, but when it's not appropriate and it's used, you typically run into problems, especially False Claims Act type of problems. My name is Dr. CJ Wolf, and I am a compliance professional with over 22 years of full-time compliance experience. I am an MD by training, but left clinical practice many years ago and have spent the last 22 years as a full-time compliance professional for organizations such as Intermountain Healthcare, University of Texas System, MD Anderson Cancer Center. I also hold university faculty appointments, and now I'm spending a lot of time as a private consultant in the compliance and coding space as well as training. I have multiple certifications in the coding areas as well as healthcare compliance. And if you're interested in potentially using our services, feel free to reach out to us at info@compliancereality.com. Okay, let's jump into the material for today. I'm going to share with you a bunch of examples of enforcement relating to Modifier 25 and its misuse. Now, Modifier 25 is used on an evaluation and management code, or an E&M code, when that evaluation and management service is significant and separately identifiable from a procedure being performed on the same day. There are times when that may be appropriate, but in general, the default is, let's say you've got a scheduled procedure. That scheduled procedure has regular preoperative and postoperative care associated with that procedure. It's not always an operation in the operating room, for example, in the OR. It could be an office procedure. And those office procedures, you do not bill a separate evaluation and management code unless it's significant and separately identifiable. So there's a lot that goes into what that means, but I'm going to share with you examples from many different specialties where this principle was allegedly abused. And the first one is with scheduled diagnostic tests. So this practice, Premier Medical Associates, agreed to pay the government $750,000 to resolve claims of false billing. And the allegations specifically revolved around adding an E&M, evaluation and management, with Modifier 25 to scheduled diagnostic services such as INR and blood tests. So these are, let's say a patient is on a blood thinner. They're coming in on a regular basis to have certain blood tests done to make sure that their medication is keeping their blood at the right thickness or thinness, so to speak, so that they don't get clots. And those tests are typically regularly scheduled, and you get the blood test, you come in, you get the blood test, and you go. Unless there's a significant evaluation of some problem and a workup that would warrant a significant, separately identifiable evaluation and management service above and beyond the normal pre-op or post-op care associated with that procedure, if you haven't done all of that, then you should not be billing an E&M with Modifier 25. Now, if you do all of that, then billing an E&M plus the procedure or the test would be appropriate. You'd use Modifier 25 to designate that E&M should be separately paid. Now, this practice, it was alleged that they were adding E&M codes in the Modifier 25 when there was not a significant separately identifiable service being performed. In addition, it was alleged that they were adding procedures to scheduled E&Ms. So when there actually was an E&M, they would tack on certain procedures even though they didn't do those procedures, like an X-ray or an echo. And what's interesting in this case, the whistleblowers were billing specialists that were employed by this practice. They're the ones who filed the False Claims Act complaint, the relators, so to speak, in a Keytown suit. And if you're just listening on the podcast version of this. I will be including all these links to each of these settlement press releases. And if you're watching the YouTube video, you will see the link at the bottom. I also will put those in the show notes so that you have all of this. The next example comes from cancer care. So that last one was just a general, I can't remember if they were internists or family practice, but they were general care physicians taking care of patients. Here, we're now into more of a specialty type of environment, which includes cancer care. And in this scenario, this cancer group was, again, billing E&M services on the same day as a related procedure when it was not a justified E&M. They ended up agreeing to pay $4.1 million to settle the allegations. Now, just think, what kinds of procedures are likely to be done by a cancer care group? Maybe it was an infusion, maybe it was injections. So these are procedures that are also have CPT codes for those procedures themselves. And the normal pre-op or post-op associated with doing that procedure, asking the patient how they're feeling today, asking, are there any contraindications for getting the infusion today? That typically is not enough to qualify as a significant, separately identifiable evaluation and management service above and beyond this normal pre-op or pre-procedure or post-procedure care. There's certain things that you do when you're doing these procedures, and that type of questioning or even brief physical exam is typically a requirement to do the procedure. Now, it was interesting that in this press release, it was noted that because of widespread abuse of the use of Modifier 25, the United States Department of Health and Human Services, OIG, has targeted the use of Modifier 25 in its yearly work plans. Later in the session today, I'm going to show you some work that the OIG has done in regards to Modifier 25 with their audits and investigations, as well as something that they have in the works that we're still waiting to get that report probably a little later in 2022. The next scenario now is urology services. When we get through all these examples, you're going to see misuse of Modifier 25 can be done in any specialty. So in this scenario, it was a urology practice that agreed to pay $1.85 million to settle these false act claim allegations. Now, what's interesting here is the whistleblower or the relator was an auditor that was hired by Skyline Urology to do an audit. And he found these issues, tried to get the practice to change, and alleged that they wouldn't change or didn't change. And then he filed this lawsuit. So specifically, the relator alleged that the Modifier 25 error rate overall for the practice to be around 58%, and it was 100% for some doctors, according to him. Interestingly, after this settlement or concurrent with this settlement, the practice agreed to a 3-year corporate integrity agreement, which requires IRO reviews. These are independent review organizations. So a corporate integrity agreement is an agreement that the OIG enters into when they feel like, okay, there's been a settlement, but we need to keep our eyes on this practice for the next little while. Sometimes they're 3 years, sometimes they're 5 years. In this case, it was a 3-year corporate integrity agreement. These are all published publicly, so you could read their corporate integrity agreement. And an IRO is an independent review organization. Per this CIA, the practice must hire on their own dime an independent review organization to do regular reviews that have to do with coding and billing. Now, the CIAs also have all sorts of compliance program requirements, things like you have to have a compliance officer, you have to have policies and procedures in place, you have to train, you have to do all these things, sometimes certifications, auditing and monitoring, that sort of thing. The one I wanted to point out, though, was this additional burden that the CIA requires the practice to engage an independent review organization to do these reviews. And the U.S. attorney involved in this case said, this settlement is an example of how whistleblowers and government can work together to recoup and deter overbilling practices. Next, wound care services. Think of wound care. There are lots of procedures that are scheduled to be done for wound care. Debridement, you might have hyperbaric oxygen therapy. There's lots of different kinds of wound care services that have their own procedure codes. And you should not be billing an E&M in addition to that procedure on the same day unless it meets the definition of that modifier, which is a significant separately identifiable E&M above and beyond the normal pre-op, and I'll say pre-procedure or post-procedure or post-op care associated with that procedure. In this case, the whistleblower alleged that Healogics, which is a Florida-based provider of wound care, that entity submitted claims using Modifier 25 to signify that a separate E&M service was performed on the same date as another procedure, when no such separate service was performed. Now, this led to a $400,000 settlement that you can see there in the title. This entity ended up entering into a 5-year corporate integrity agreement. And again, that CIA requires independent review organization reviews. The U.S. attorney involved in this case said, "We encourage citizens with knowledge of wrongdoing by healthcare providers to bring those matters to our office's attention." Most of you know that under the False Claims Act, qui tam relators or whistleblowers, if the government is successful in obtaining some sort of settlement or financial recoupment, the private citizens who brought those things forward, typically they're employees or past employees of the organization because they have some sort of inside knowledge, they can be given a percentage of the recovery. So there is a financial incentive to do that, and this has made the False Claims Act, a very strong and probably the most powerful tool that the government has, because the government more or less waits for people to bring them the cases and bring them the information from an insider's perspective. Of course, the government is doing proactive work as well, but the vast majority of these cases are brought from the qui tam side of the False Claims Act. Eye services. Think of all the eye procedures, think of injections, think of eye scans, all of these types of services that have their own procedure code. And so reimbursement for that procedure includes all the pre and post procedure work. So you don't just show up and, go right to the eye procedure. Somebody usually asks you how you're feeling today, or they'll do some vitals, they'll do some of that preliminary work to make sure that it's safe to proceed with the procedure. That type of work is almost always considered a part of the procedure itself. It's a part of that normal pre-procedure or pre-op or post-op care. In this particular case, the entity, the whistleblower alleged that the practice improperly used Modifier 25 to charge for E&M services that, again, were not separately billable from other eye procedures performed on the same day. This entity entered into a corporate integrity agreement as well for 5 years that also requires IRO, again, independent review organization reviews. This was Southeastern Retina Associates in Tennessee. The U.S. attorney involved in this case stated, "It is important that medical providers present appropriate and reasonable charges for services that are paid for by the taxpayers. This office remains committed to ensuring that publicly funded healthcare systems are not charged more than what the billing rules prescribe." Again, False Claims Act, the Federal False Claims Act deals with claims made to the federal government. That includes Medicare claims, often Medicaid, TRICARE, some other payer types. And so that's why this statement by the U.S. attorney is talking about services paid by the taxpayer, because tax dollars obviously fund a lot of those programs. Now, it's not just doctors, hospitals too. So Modifier 25, you often think of an evaluation management service as a professional service, meaning it's a service performed by doctors or nurse practitioners or PAs, which is true. Those are called E&M codes, evaluation and management. However, under, for example, the hospital outpatient prospective payment system, hospital visits also can be paid, and though the rules sometimes change from year to year and the codes used might change from year to year, there are scenarios where modifier 25 could be used to also, again, bill for a procedure that maybe was scheduled that day, and then also bill for an evaluation and management service. But that modifier 25 still means the same thing. It has to be significant, separately identifiable from that procedure. And it has to be above and beyond that normal pre-procedure or post-procedure work. In this case, I found this interesting because the whistleblower was the former director of the compliance department. This hospital in Tarrant County, which I believe is in Texas, John Peter Smith Hospital, agreed to pay $3.3 million to settle. And one of the things that this former director of compliance alleged was that they were misusing modifier 25. On the right of this slide here, I've looked into the court documents that are publicly available and found one of the exhibits was a 12-page internal audit report that was included in those court records. And you can see just page number 1 here. This was a 12-page internal report that was distributed to various leaders. The whistleblower here alleged that they did nothing after she reported this information. You can see, hopefully on the slide, you can see the pages of this 12-page report, an executive summary, the objective and scope, background, rationale, their findings, and corrective action plan process, recommendations, methodology, corrective action plan, those sorts of things. If you're interested in getting that 12-page internal audit report, feel free to email us at the email info@compliancereality.com, and I can get that to you. It's an interesting read. It goes through and identifies how they did the audit. How did they identify which claims to look at? What were their error rates? What do they recommend in correcting this type of issue? And I think it's a pretty decent audit report. And unfortunately, in this case, it was alleged that the hospital did nothing with that report, or did very little. Again, most of these cases settle, so no one admits guilt. These are allegations. And unless they go to court and someone's found guilty in court, these settlements typically say that, you know, the defendant will not accept or will not admit liability or fault. Here's another one from a hospital. Now, this one was in Massachusetts. Massachusetts Eye and Ear Infirmary, which agreed to pay $2.6 million to resolve False Claims Act allegations. Again, this has to do with modifier 25. This one is interesting because it was a patient who was the whistleblower, according to the press release. And in the press release, they thank the patient for their courage to come forward and to report this. It was alleged that over an 8-year period, the hospital submitted claims to Medicare and Mass Health. Mass Health is the Medicaid program in the state of Massachusetts at the time. For office visits in conjunction with claims for nasal endoscopies and laryngoscopies. So these are procedures, and nasal endoscopies and laryngoscopies have their own CPT code. They have their own procedure code, and included in the reimbursement for that, you know, are the questions and the evaluation you do. So usually these are scheduled procedures. You schedule them out. You probably already did your E&M, your initial consultation, or your initial evaluation management. It is possible that you do an E&M and then do the procedure in the same day, but that's the exception, not the norm. Some practices might be set up for that to be the norm, but you have to be very careful and make sure that when you're billing an E&M with modifier 25, when you put that modifier on there, you're certifying that the evaluation and management service is significant and separately identifiable from the procedure, that it's not the normal pre-op and post-op or pre-procedure, post-procedure work that goes into doing a nasal endoscopy or a laryngoscopy. They stated that they billed these claims when the otolaryngologist did not actually perform significant and separately identifiable E&M services during the period from January 1, 2012 to February 2020. So you have this 8-year period. And on the next example, Again, it's a hospital example. This was Geisinger Medical Center located in Pennsylvania, I believe. They agreed to pay, and this one was a few years back. I want to say 2011-ish. This hospital agreed to pay 1.3 million to resolve allegations that it misused Modifier 25. And interesting on this, the U.S. Attorney General, or the U.S. Attorney who was involved, Peter Smith, said that from January 1, 2001 through December 31st of 2006, Geisinger, quote, erroneously submitted claims to the Medicare program for payment that contained evaluation and management services that were not allowable under the Medicare program's requirements. In other words, procedure performed on the same day. Now, from the Geisinger side, Thomas Sokola, I don't know if I'm pronouncing that right, who at the time was the Geisinger Chief Administrative Officer, said, quote, this issue concerns interpretation of what is known as Modifier 25, which enables providers to bill for additional payment for a separate medical evaluation and treatment. Medical coding principles are very complex and technical in nature. As such, there are significant differences of opinion among coding professionals as to the correct criteria relating to Modifier 25 billings. Emphasis added. I added the underline in bold for this particular one because I wanted to emphasize that point about medical coding principles are complex. And I agree with that. They can be complex. They can sometimes be subjective in some regards. And that's why I think it's important, especially if you're doing an audit or you need help with determining, is this evaluation and management service truly significant and separately identifiable from the procedure? You need somebody typically with some clinical background to make that determination and say, you know what? What's documented here really is a part of the procedure that's already being billed, and a separate E&M is not warranted. And so I agree with their chief administrative officer that there are many opinions. And I think it's important that you get somebody who understands these issues when you're evaluating Modifier 25 in an audit, for example. So those were all examples of either settlements or enforcement action when either physicians or group practice or even hospitals allegedly misused Modifier 25. So let's talk about what the OIG has done or is doing proactively on Modifier 25. They've done a lot of work over many years. First, let me just start with this quote, what the OIG stated about Modifier 25 from their website. They put it into the category of upcoding. They say another example of upcoding related to E&M codes is misuse of Modifier 25. Modifier 25 allows additional payment for a separate E&M service rendered on the same day as a procedure. Upcoding occurs if a provider uses Modifier 25 to claim payment for an E&M service when the patient care rendered was not significant, was not separately identifiable, and was not above and beyond the care usually associated with the procedure. That's kind of what I've been saying throughout this video as well as podcast. That's really the definition of Modifier 25. And the OIG has gone on the record to say, look, this is a possible area of misuse. So what have they done? Well, over the years, they've done various audits and investigations. This slide is about a report that they published on use of Modifier 25. And they looked at one particular calendar year, and in that one calendar year that they looked at for those sample claims, the OIG identified 35% of claims using Modifier 25 did not meet the payment requirements. So that's more than 1/3. So more than 1 out of 3, just around 1 out of 3 claims that used Modifier 25 did not meet the payment requirements. And this equated for their sample and for the year that they were looking at $538 million in improper payments that they estimated. Again, that was just for one calendar year. That's a lot of money. In their report that's referenced here with the link, OIG recommended that CMS reinforce the requirements that E&M services billed using Modifier 25 be, quote, significant, separately identifiable, and above and beyond the usual preoperative and postoperative care associated with the procedure, end quote. Again, a lot of the same things that I've already been saying, but this was a study, investigation, or audit, one could say, that the OIG did on use of Modifier 25. It's a longer report than what we can share on just this one slide, and so if you're interested in this one, you might want to use this link and go read the report for yourself. Now, this next slide shows one finding of a larger kind of scope report. The report that was done was on questionable billing for Medicare ophthalmology services. So this was an investigative report that the OIG did on ophthalmology services overall. And so it focused on all kinds of billing, questionable billing in that specialty. One of their findings dealt with modifiers. And so I'm not going to go over all the other ophthalmology services, though if you're interested, you might want to read this report, or let me know via email if that's an interesting topic for you, and maybe we can do a video and podcast just on that topic. But one of their findings that they reported on for questionable billing was Modifier 25 misuse, and another modifier, which is Modifier 24. We're not going to go into that a lot. The majority of their findings had to deal with Modifier 25. But for one calendar year, the OIG identified 566 providers with unusually high billing for ophthalmology E&M services with modifiers, and that equated to $18 million in claims using modifiers 24 and 25. Again, the majority is by Modifier 25. And that, again, is for one calendar year. They said, quote, providers that submit an unusually high percentage of claims with modifiers 24 or 25 may be using the modifiers to inappropriately receive payment for these services. So they hinted, and in their review, they found potential evidence that this was a problem. Now, the next thing, before I mention the next step that the OIG is working on, I want to share with you a dermatology settlement, because it kind of sets the stage for my next slide. This is a settlement from a dermatology group of physicians. They settled to pay $1.9 million regarding overbilling for evaluation and management services, specifically Modifier 25. The allegations here were that the physicians were billing for E&M services on the same day as a procedure. Think about a dermatologist. They do all sorts of procedures. They do biopsies. That has its own procedure code that gets paid. They do lesion excisions. They do laceration repairs. All of these procedures have their own procedure codes, and unless the E&M is significant, separately identifiable, et cetera, what we've been saying over and over again, you should not be billing a separate E&M on the same day as the procedure unless it is truly significant and separately identifiable from the procedure. What was stated in this press release was, quote, providers are not permitted to bill both E&M services and a procedure on the same day under the Medicare program's regulations unless a significant, separately identifiable service has been performed. This entity, as you can see on the slide, entered into a 5-year corporate integrity agreement, which requires IRO reviews. Again, those independent review organizations that the practice has to hire to do reviews. Now, the reason I'm sharing this settlement with you is because the OIG has put on their work plan this. Specifically, working with Modifier 25, dermatologist claims for evaluation and management services on the same day as minor surgical procedures. So this is something they've announced to put on their work plan. The expected finished report is to be issued sometime in the year of 2022. Specifically, they stated that payment for procedures, as I've been stating throughout this session, include the necessary pre- and post-operative services. You can't just do a procedure without doing the necessary pre- and post-op work and care of the patient. They also state, in general, E&M on the same day as a procedure is included in the procedure and not separately reportable, reimbursable, including the decision to perform a minor procedure. They also state that for 1 year, when they did a review of data, about 56% of dermatologists' claims within E&M service also included minor surgical procedures, such as lesion removals, destructions, and biopsies on the same day. And lastly, on this slide, they said, quote, "This may indicate abuse." They go on to explain what they mean, but I wanted just to highlight those words. That's something they're going to be looking at. So that wraps up our discussion on Modifier 25. We highlighted many enforcement actions, both on against physicians and practices, as well as hospitals, and we also highlighted the work that the OIG has done in this area, as well as an item that they're currently going to do and report on in the future. If you have questions or comments or ideas for new topics, please email us at info@compliancereality.com. And lastly, if you need help with your compliance program, I hope that you'll consider our consulting and training services. And again, you can reach us at info@compliancereality.com. Thanks for listening to another episode. Have a great day.